Welcome to the Deep Dive. We're here to cut through the noise and pull out the insights that really matter for you. Today, we're looking beyond Portugal's, beautiful beaches and culture.
Yeah.
We're diving deep into something absolutely vital if you're living in Portugal or own property there. Inheritance law. Our goal is simple. Untangle the complexities and give you the clear, actionable knowledge you need. Fast.
Exactly. And think about it, with maybe 720,000 foreign residents, plus all the international property owners, understanding the system is, well, it's essential. It's this really interesting mix of old legal traditions and modern EU rules. And that mix, as we'll see, creates some unique challenges, but also some significant planning opportunities.
Okay, so let's kick things off with the big one, the thing that often catches people out right away. Portugal's forced heirship system.
Yes. That's often a huge shift, especially for people from common law backgrounds. It's called legitima. Basically, the law reserves a big chunk of the estate, usually between half and two-thirds for close family. We're talking spouses, children, grandchildren, and if there aren't any descendants, then it goes up the line to parents and grandparents. The key thing for you to grasp is that these rights are mandatory. You generally can't just write these people out of your will, except maybe in really extreme situations, and you have to prove that in court.
Right. So give us a practical example. Let's say you're married, you've got kids. How much control do you actually have?
Well, less than you might think. In that scenario, you can only freely decide what happens to one-third of your estate via your will, the other two-thirds. That's reserved. It gets divided between your spouse and your children.
And the spouse has extra protection.
Yes, the spouse is protected. They can't receive less than one-quarter of the whole estate.
Okay. But it changes a bit if you only have a spouse or only children.
It does. In those cases, the reserved portion drops to 50%, so that gives you a bit more freedom with the other half.
Makes sense.
Now, here's where things get interesting for EU nationals. There's a really important planning tool. EU Succession Regulation 650/2012. Most people just call it Brussels the Fourth.
Brussels the Fourth. Okay, what does that do?
It allows you, as an individual, to formally choose your home country's inheritance law to apply to your entire estate. This choice lets you effectively sidestep Portugal's forced heirship rules.
Wow. Okay. That sounds powerful.
It is. But the absolutely critical point, and you cannot miss this, is that you must make this choice during your lifetime. And it has to be clearly stated in your will. Your heirs can't just decide to do it after you've passed away.
Got it. Lifetime decision in the will.
And just a note, this applies across the EU, but not Denmark or Ireland, and obviously not the UK anymore.
So this is really the game changer then. Brussels the Faith gives you a way to regain control over your own estate planning. You get more individual autonomy, even though you're still subject to Portuguese tax rules.
Precisely. It separates the governing law from the tax implications.
Right. Let's talk taxes then. I've heard Portugal described as, maybe surprisingly, family-friendly when it comes to inheritance tax. Is that fair?
It is, yeah. It often surprises people. Portugal doesn't have that sort of escalating inheritance tax you see elsewhere. Instead, there's a flat 10% stamp duty. It's called imposto do selo. But, and this is the big advantage, that 10% only applies if the inheritance goes to non-immediate family.
Non-immediate, so siblings, nieces, nephews, friends.
Exactly. For your spouse, children, grandchildren, parents, and grandparents, there's a complete exemption. No stamp duty at all.
Wow. That's a huge difference compared to somewhere like Spain or France.
Oh, absolutely. Spain can go from, 7.65% way up towards 90% in some cases. And France has rates from 5% up to 60%. So, yes, Portugal is very favorable for close family.
And this tax, it only applies to assets in Portugal, right? They don't tax your worldwide assets.
That's correct. It follows a territorial principle. Only Portuguese situs assets are subject to the imposto do selo.
Okay. And for property specifically, there's an extra bit.
Yes, just a small clarification there. Transferring real estate does incur an additional 0.8% stamp duty. So if, say, a sibling inherits a Portuguese property, the total tax hit would be 10.8%.
Right. 10 plus the 0.8. Makes sense.
Now, we do need to mention a pretty significant recent change, the non-habitual resident regime, the NHR, that's closing.
Ah, yes, the NHR, end of March 2025, is it?
Correct, March 31st, 2025. So if you already have NHR status, you keep your benefits, including any inheritance tax exemptions, for the rest of your 10-year term. But no new applications are being accepted after that date.
And the replacement scheme? IFISI is a...
Yes, IFSI. It's much more targeted, aimed at, specific qualified professionals, researchers. And honestly, right now, it's not clear what, if any, inheritance benefits it will offer. It feels like a move away from those broad tax incentives.
Okay, so the landscape is shifting slightly there. Let's talk process. You mentioned strict deadlines. That sounds like a potential minefield.
It really is. You have to be on the ball. The timelines are non-negotiable. First, you've only got 48 hours to register the death at the civil registry. 48 hours.
Very tight.
Then there's a 3-month deadline for the tax declaration, and this is crucial. You must declare all Portuguese assets, even if you think no tax will be due.
And if you miss that...
Penalties. And daily interest. It adds up fast.
Okay, what's next?
Payment. You have 6 months to pay any stamp duty owed. Again, miss that, and interest starts accruing. Although, sometimes you can arrange installment payments, maybe up to 10 months, but that needs specific approval.
Right, so deadlines are critical. What about the actual paperwork, especially for property? If you inherit a house in the Algarve, what hoops do you jump through?
It can feel like a lot of hoops, yeah, but it's a set procedure. First step is usually getting a certificate from the IRN, that's the Instituto dos Registros e do Notariado, just to see if there's a Portuguese will registered.
Okay.
Then you need to formally establish who the heirs are. That's done with a notary through a deed called habilitación de herederos, basically, a deed of heir qualification.
Habilitación de herederos, got it.
And finally, you record the actual transfer of ownership at the land registry, the Conservatoria do Registro Predial.
And the documents needed. Original deed, land registry certificate.
Yes, those, plus the tax authority's property document the caderneta predial. You'll need proof you paid the stamp duty too, if any was due.
What's the trickiest part for heirs living outside Portugal?
Often, it's getting foreign documents sorted. Things like birth or marriage certificates need to be apostilled or legalized, depending on the country. And then you need official certified Portuguese translations for everything. That can be time-consuming and add costs. The whole process for an international estate, you're probably looking at over a year, realistically.
Over a year. Wow. That sounds like a lot of back and forth if you don't live there. Is there a way around that?
Yes, definitely. A very common and practical solution is for non-resident heirs to set up a Portuguese power of attorney.
Ah, so someone local can act on your behalf.
Exactly. You grant power to a lawyer or representative in Portugal, and they can handle all the paperwork, notary visits, tax filings, everything. Saves you multiple trips.
Smart. What does setting up a power of attorney typically cost? Ballpark.
You're probably looking at around 250 GIL plus VAT for the legal fees to draft it. Then maybe €30 for the apostille if you're signing it abroad, plus notary fees, of course, but usually well worth it for the convenience.
Okay, good tip. Now let's shift gears a bit. Here's where it gets really interesting. The whole area of digital assets. Crypto, online accounts. How does Portugal handle that?
Well, that's the thing. It mostly doesn't. Not specifically, anyway. Portugal, like a lot of places, doesn't really have dedicated laws for digital inheritance yet.
So what happens?
These assets, cryptocurrency, social media accounts, cloud storage, digital subscriptions, they just fall under the general inheritance rules. And those rules, frankly, weren't designed for assets protected by passwords, encryption, two-factor authentication. It creates huge practical problems.
Like just finding the assets in the first place.
Exactly. Or proving ownership, or even accessing them without violating terms of service. It's a real regulatory gap.
And if you inherit something like Bitcoin, does that 10% stamp duty apply if you're, say, a nephew?
Technically, yes. If you're a non-exempt beneficiary, the 10% imposto do selo should apply to inherited cryptocurrency.
But how do you value it? The price swings wildly.
That's the challenge. It has to be valued at the date of death. For crypto, that can be tricky. Plus, remember, Portugal now has capital gains tax on crypto held less than a year, 28%. That adds another layer.
And what about things like social media accounts? Can your heirs access those?
This is where platform policies often clash with, or maybe override, local law. The terms of service you agreed to might dictate what happens, and they might not recognize Portuguese inheritance rights at all. Executors can find themselves completely blocked.
So the takeaway here is really about pre-planning, isn't it?
Absolutely essential. You need meticulous, accessible records of all your digital assets. Logins, passwords, maybe stored securely, and look into platform-specific tools. Some now offer legacy contact options. It's a crucial part of any modern estate plan.
Okay, let's unpack this further. For you listening with ties to multiple countries, things get even more complex. Cross-border tools become vital, right?
Spot on. And the starting point under Brussels IV is often figuring out habitual residence. That determines which country's laws and courts have jurisdiction.
And it's not just about where you have an address.
No, not at all. Portuguese courts, for example. Look at the whole picture. How long have you lived there? Are you socially integrated? Where are your main economic ties, your family connections? Think about maybe a retired British couple who spends 6 months in the Algarve and 6 months back in the UK. There could be genuine uncertainty about which country is their habitual residence for succession purposes.
That sounds like a recipe for confusion. Is there anything to help simplify that?
Well, for heirs within the EU, there's the European Certificate of Succession, the ECS.
ECS, what does that do?
It's designed to provide a single, uniform document proving your status as an heir, administrator, or executor. It's valid across participating EU member states without needing extra legalization.
So Portuguese authorities would recognize an ECS issued in, say, Germany.
Yes, they issue and recognize the ECS. It definitely helps streamline things. Though, be aware, for registering property in Portugal, you might still need a separate Portuguese partition deed, even with an ECS.
And there's a time limit on it.
Yes, the ECS is typically valid for 6 months, so you need to move fairly efficiently once it's issued.
Okay. And then there's the issue of potentially being taxed in multiple countries. Double taxation treaties must be key here.
Absolutely crucial. Portugal has a wide network, over 80 double taxation agreements. They generally follow standard OECD models. Typically, your country of residence gets the primary right to tax your worldwide estate, but the country where assets like real estate are located often retains the right to tax that specific asset.
So the treaty prevents you paying full tax in both places.
Essentially, yes. It provides mechanisms for tax credits or exemptions, but you need to actively claim the benefits. That usually involves getting official tax residence certificates and making sure all the documentation is correct. It requires careful handling.
Right. With all these layers, let's focus on smart planning. What are the key strategic opportunities for you as a foreign resident or property owner in Portugal?
Well, as we touched on, for EU nationals, the Brussels Lafite election is probably the single most powerful tool. Choosing your home country's law to govern succession gives you significant control, bypassing forced heirship while keeping Portuguese tax rules in place. But remember, explicit statement in the will during lifetime affects the whole estate. Can't cherry-pick assets.
Okay, Brussels Lafite is key for EU citizens. What about other tools? I heard life insurance mentioned as being particularly useful.
Yes, it really can be, particularly certain types like unit-linked life insurance policies,
Unit-linked. Why those specifically?
because they often combine investment growth potential with significant inheritance planning advantages. Crucially, the policy proceeds can often pass directly to your named beneficiaries outside of the formal probate process.
Bypassing probate. That sounds like a major time and cost saver.
It can be, absolutely. It streamlines things considerably. Companies, especially those based in places like Luxembourg, have developed quite sophisticated policies tailored for residents in countries like Portugal, offering professional management too.
How does that compare to using something like a trust?
Big difference. Portugal doesn't formally recognize trusts in the same way common law countries do. In fact, distributions from foreign trusts can be taxed quite heavily, often at a flat rate of 28%. So life insurance is generally a much more tax-efficient route in Portugal.
Good to know. What about giving assets away during your lifetime? Gifting.
That's another valid strategy to consider. Interestingly, the stamp duty rate for gifts to non-exempt recipients is the same 10% as for inheritances.
So no tax advantage there for, say, gifting to a nephew.
Not directly on the rate, no. But the big advantage comes from the exemptions. Remember, gifts between spouses, parents and children, grandparents and grandchildren are completely exempt from that 10% stamp duty.
I see. So you can transfer significant wealth to close family during your lifetime, tax-free.
Exactly. It allows for staged wealth transfer, potentially reducing the size and complexity of your estate later on, simplifying the eventual inheritance process.
Okay, now here's a really interesting angle you mentioned. The specific advantages for citizens from other Portuguese-speaking countries,
Yeah.
the CPLP nations.
Yes, this is a really significant benefit that's often not widely known outside those communities. Citizens from the community of Portuguese language countries enjoy much easier immigration and residency rules in Portugal.
How much easier?
Well, for Brazilians and Timorese citizens, for example, they can enter Portugal as tourists and then apply for the residence permit after they arrive. The process can be incredibly fast, sometimes just 72 hours, and the fee is minimal, like €15.
Wow, compared to the usual visa processes, that's night and day.
It really is. For
Sure.
citizens of the other CPLP countries, Angola, Mozambique, Cape Verde, Guinea-Bissau, São Tomé and Príncipe, Equatorial Guinea, they generally still need a visa beforehand. But even for them, the documentation requirements are often simplified, and the processing tends to be faster than for other third country nationals.
And this links to nationality, too.
Yes, a huge advantage. CPLP citizens typically only need 5 years of legal residence in Portugal to apply for Portuguese nationality. For most other foreigners, it's 10 years. Plus, Portugal allows dual citizenship, so they don't have to give up their original nationality.
5 years versus 10. That's a big difference. How does this connect back to inheritance planning?
Well, gaining Portuguese nationality obviously opens up the potential to use Brussels the Fourth if they wish, choosing Portuguese law perhaps, or simplifying administration generally. It removes hurdles, and there are other related benefits, like social security agreements between CPLP countries. These ensure pensions and survivor benefits transfer more easily, which is also part of long-term family planning.
Fascinating. Okay, let's get down to the practicalities, the costs. What's the real bottom line for your budget when dealing with inheritance administration in Portugal?
It's crucial to budget realistically. As a rough guide, total costs often land somewhere between 3% and 5% of the estate's value.
Okay, 3–5%. What makes up that cost?
You've got mandatory fees first. Notary fees for the deed of acceptance start around €600. If property is involved, the transfer deed could add another 500 to €1,000, maybe more if it's complex. Registering the change at the land registry is about 225 plus VAT, usually.
That sounds manageable so far. Where do the bigger costs come in?
Legal fees. For international estates, having a Portuguese lawyer is pretty much essential. Navigating the system, dealing with translations, deadlines. They typically charge based on a percentage of the estate value, often 1% to 2%, but usually with minimum fees. You might see minimums of $3,000 to $5,000, even for smaller estates.
Right. Legal fees can add up. Anything else?
Translation and legalization costs. Certified translations aren't cheap, maybe €50 to €150 per document. Translating a complex foreign will correctly could easily cost €200 to $500 or more. It all mounts up.
And beyond these direct fees, the timeline itself has costs, right?
Right.
Frozen assets, ongoing property costs.
Absolutely. That's a hidden cost, but a very real one. While the estate is being processed, which, as we said, can take over a year internationally, assets might be frozen or inaccessible. Property maintenance bills, condo fees, utilities, they all keep coming. And currency fluctuations over that period can impact the final value received by heirs.
It really drives home the need to manage that timeline proactively.
Critically important, you really need to instruct Portuguese legal counsel very quickly, think days, not weeks after a death. They can get the ball rolling, track those deadlines meticulously, and avoid simple procedural errors that can cause delays and trigger those penalties and interest charges we talked about.
So acting fast saves money and stress in the long run.
Without a doubt, procrastination is very expensive in this context.
Looking forward then, what's the general outlook? Can we expect big changes to Portuguese inheritance law anytime soon?
Honestly, Portuguese inheritance law has been remarkably stable over the years. Major reforms don't seem to be on the immediate horizon, despite ongoing talks at the EU level about harmonization. We might see some smaller tweaks, maybe improvements to the inventory process, potentially giving heirs more choice between using the courts or a notary.
And the digital asset cap.
I think that will have to close eventually. As crypto becomes more mainstream and digital life expands, lawmakers and platforms will need to provide clearer pathways. It's inevitable, just a question of when. And as the new iFi regime settles in, we should get more clarity on how it impacts inheritance for those qualifying under it.
So connecting all this back to the bigger picture for you listening, it sounds like despite the complexities, the current Portuguese system actually offers a fair amount of predictability.
I think that's fair to say. Yes, it's complex, especially cross-border. But the tools are there. You've got the Brussels Waters option for EU nationals. You've got those very helpful tax exemptions for close family, and there's good professional support available. It creates pathways for effective planning, which really leads to a final thought, maybe a question for you to consider. Knowing all these nuances, especially around digital assets and cross-border issues, what would be your very first practical step today in either creating or perhaps reviewing your own estate plan for your assets in Portugal?